So welcome back, Constitutional Coalition here,
Right.
with Thor Hearn, and we're going to talk about amicus briefs.
Yeah. So, an amicus brief, we were talking before about how we interact with the judicial system, or what we call jurisprudence, the body of law that governs our civil society. Everybody's familiar with the Supreme Court, with courts that process. That process resolves not only individual disputes, say somebody's getting a divorce, somebody bought a car and there's some problem with the car, somebody had a problem in a civil matter.
A celebrity
That's
suing another celebrity for defamation, perhaps.
right. So there's a lot of those issues that are what I would call personal or parochial to the individual people living in society. We need to have a fair, just, and prompt system to resolve those disputes. And we need to all have confidence that it's fair and just. But those disputes also involve not just individuals with specific people's court kind of disputes over rent or something of that nature, but it deals with issues that affect every one of us for the whole country as a whole. And those are issues where we also entrust the judicial branch to have a significant role, not the only role, but a significant role in resolving those disputes.
Is that when the smaller courts just go up the chain of command, so to speak?
Yes. So everything starts, any court case that ends up in the Supreme Court begins in a trial court. So it goes to a trial court, either a state or a federal trial court, finds its way to an intermediate court of appeals, again, either a state court, could be a state Supreme Court, or it could be a federal circuit court of appeals. And then a select handful of those cases, the Supreme Court only is able to hear about 100 or so a year of those disputes go to the Supreme Court itself. So because the Supreme Court can only resolve a limited number of those cases a year, they can only pick the most important ones. And those are generally cases that involve the entire community, the entire society, the entire country.
Is there a process for how they select which cases are going to hear and going to?
There
rule on?
is, and it's called, like, lawyers always want to speak in Latin whenever they speak. I don't know, it maybe justifies higher hourly rates to be able to
When they speak in
translate
Latin?
it in Latin. So it's called a writ of certiorari.
Okay.
All that means is it's a petition, a request to the Supreme Court to hear and review a decision of a lower court, whether it be a lower state Supreme Court or whether it be a lower court, federal court of appeals. There are some category of cases the Supreme Court has what we call original jurisdiction over, lawsuits between states, but that's a relatively rare portion of what they hear. So to have the Supreme Court hear a case, it goes up on what we call a writ of certiorari. At that point, the issues, the factual issues, have all been, or should have all been, basically resolved in the lower courts, particularly the trial court. So the trial court sorts out the facts and says, here are the facts, and then they decide, here's the law the way we, the trial court, decides or believes the law should be applied. That is all subject to what we call de novo review. De novo meaning new review. So you can review it, the reviewing court, Court of Appeals, looks at it for the first time and is not bound by what the lower courts say the law is. So the reviewing court, again, the Court of Appeals, and ultimately the Supreme Court, will decide, here's what we think the law is, and we're not bound by what the lower court did. So on that record, the factual record, the legal issue goes forward, and ultimately, we hope, in very important cases, goes to the Supreme Court. But there's a rule at that point, just because the decision of the Supreme Court is almost always going to have implications for everybody else in the country. It's rare that you would have a Supreme Court decision that would be very limited to just the people who are parties to that case. So the whole country has an interest in watching the cases that go to the Supreme Court and how those cases are presented and what issues the court decides. And that provides a rule for what we call amicus curiae parties. Now, again, we're speaking Latin, but it just means friend of the court. And the role of a friend of the court, an amicus curiae, is to provide the court a perspective, a historical perspective on the issue the court's considering, a legal perspective, even a cultural perspective to help the court, the Supreme Court justices that are deciding that case, have a full-orbed appreciation of the implications of what they're being asked to decide. So that's where the role of amici comes into play and can be very important.
So can anybody just write an amicus brief, or do you have to go through lawyers and go through sort of the legal chain of command, if you will?
Anybody can write an amici. You could write an amici. I could write an amici. The important point is not so much that anybody can write it and file it with the court. It's really the weight of the amici, the reasoning they present, the reputation they bring to the court. So very distinguished law professors frequently write amici briefs. And the amici briefs, in many cases, have a significant influence on how the court decides the case. So there's an important role to have that voice presented to the Supreme Court. Now, the amici can also speak for themselves or for a particular interest group or a particular component of people in our country who want to make sure their voice is heard because that the court considers their perspective because the decision the court makes will affect them even though they're not a party in the case. And so that's why what I would consider an active amici practice is an important component of having good decisions by the Supreme Court. So that's one role that the Constitutional Coalition can provide, working with others to provide that voice to the court when they have these compelling decisions that they have to enter, working individually or with others in presenting that view.
And this can be done federally to the Supreme Court, also to a state court, if
Yes.
necessary. Okay.
So an amici brief is not just in the Supreme Court. It can be in a lower federal court, which is often very important as well, or a state Supreme Court. And the goal is to make sure every court, let me back up a half step. Every court, we think of the Supreme Court with this big building in Washington, D.C., right across the street from the Capitol with, on Capitol Drive there with Moses on the motif of the Supreme Court and
very beautiful
big halls and pillars and all that. So as an institution, it's quite distinct, but ultimately, it comes down to 9 individuals who are appointed, and they're trying to make the best decision they can. And through history, there's a lot of decisions that come down to a 5-4 split where you don't have agreement. But whatever the majority decides, that then becomes the law of the land. So 5 individuals on these very close and important questions can really determine how all of us are going to be living our lives. And so that's why it's important to be aware of that process and have a voice in that process.
Wow. So an amicus brief has a lot of weight, a ton of weight.
It can.
If done appropriately.
It can if it's done appropriately, respectfully, and with good authority and sound reasoning. And so there is and the point I would make is there's a vital role for that to happen. For an amicus brief. And you look back through history with the Supreme Court, it did not used to be in the early days that amicus briefs were very common. But particularly in the modern era of Supreme Court jurisprudence, amicus briefs are becoming much more important. And particularly, again, on these critical issues that have great cultural and societal impact, the court does look at amicus briefs.
Okay. Has the coalition been involved in any recently, or?
So one we did this past year that was, I think, very important. In fact, it was quite important, was the case in which we had the question, which I think almost everybody watching this would be familiar with, is that we had a question of presidential immunity. Could President Trump, after he left office, be prosecuted for actions he took while he was president? That's the question. Or does the president enjoy immunity from civil and criminal prosecution. Now, the court had heard that question before in the civil context in a case brought against President Nixon, but they now had it to decide in the question of President Trump, where under what many think is lawfare, where somebody's trying to use the legal system to create a tool to advance a political agenda and prosecute their political opponents, in this case, President Trump. What level of immunity does the president have? Again, apart from President Trump, that issue is far more important than President Trump or who won the 2024 election.
A little bit loaded, a little bit biased or one-sided, perhaps.
It was, well, I would say that decision, the fundamental constitutional importance of the presidential immunity decision, while everybody had strong feelings about it and a lot of emotion, take it away from the current 2024 political environment. That decision was one of great consequence constitutionally, I would say, on the order of Marbury versus Madison.
Yeah.
And the importance of having the court render that decision in the right way is really, as Justice Gorsuch said, it was either Gorsuch or Alito said during oral argument. He said, well, we're being asked to make a decision for the ages. This is not just about 2024 and who is or isn't going to be president, or Donald Trump or not Donald Trump. This is a question about the role of the chief executive, the president of the United States, how this country is going to be governed, how our three branches of government are going to function. And so you have a case of that magnitude that literally will be of importance for hundreds of years in terms of how the United States of America is governed. There's an importance to have the court benefit from that full role. So, in answering your question, with that context, what we thought was important is that former presidential administrations, not President Trump's administration, not somebody who's associated with President Trump or even aligned or defending President Trump, provide the court a perspective on the importance of that. And so
an objective view.
Correct.
Okay.
And the implications of really what they're being asked to decide. So former Attorney General John Ashcroft, who's from Missouri, but was the Attorney General during 9/11 under the Bush administration. So he has no affiliation with President Trump. He and there were many others, former Attorney Generals, including Ed Meese, that also, in another amici, filed their opinion that was also quite important, said you need to understand when the president makes a decision, he needs to make that decision on the basis of what's best for the country, what he has, without having to worry about a political opponent coming in after the fact and trying to prosecute him criminally for a decision he made while president. And that was the implications of that are profound.
Well, when you put it like that, it's how could you get anything done? Somebody's going to come after you and disagree or not like your decision.
Right. And that's exactly it, Laura, is when you have a president saying, well, here's what I think is best for the country, but you know what? If somebody later in 2 years comes and a political opponent disagrees, they're going to try to throw me in jail. That is a chilling effect, and it prevents the president as chief executive from filling the role with the vigor and the authority and the judgment that our founders intended. So that was such an important issue that we thought it was very important to have a voice before the court of somebody outside the Trump administration. In this case, former Attorney General John Ashcroft, who, as I said, was present with President Bush when they were trying to decide how to respond to 9/11 and the terrorist attacks and all those decisions that had to be made then in the aftermath of 9/11, and to do so in a way that didn't cause the president to fear political retribution, but really the freedom to make the right decision, even if it was the wrong decision. And we noted that point in the brief we presented, that historically there have been cases where the president has made the wrong decision, but it was his official decision. I mean, the example that we used particularly in our brief was the situation of President Roosevelt with Komatsu, where the Japanese on the west coast of the United States were interred. That was a blatantly unconstitutional decision. It was a massive violation of tens, if not hundreds of thousands of American citizens' constitutional rights. But it was a decision that was made 4 months after Pearl Harbor. It was
And
made.
it felt right at the time, right? Like it seemed like the right move for
And
that
it
time in
was-
history.
At that time, there was debate about it. I mean, even the Attorney General, President Roosevelt's Attorney General, told him, "I don't think this is the right decision to make. I think there's some constitutional problems." Yet they went ahead with it because the military was saying that they needed to do that to keep the United States safe. Now, that's a perfect example of a bad decision by a president, an unconstitutional decision. But the question then came, well, does that mean he should go to jail? Should FDR have been put in jail
sounds
and
crazy.
criminally prosecuted
When you put it like this, in
after the fact?
2025, should FDR be in jail? It sounds ridiculous.
Well, and that's the point.
Yeah,
is
but it was
that-
so far removed, I realize, in time from that, but I understand.
Well, no, and that's exactly the point. The point is, if FDR was saying, well, I really think this is right for the country, even though it wasn't, and even though it wasn't constitutional, he still had the freedom to make what the people elected him to be chief executive. I'm pausing for a second to note this fundamental point. There's only one branch of government, that's the executive branch, the President of the United States, who is actually elected by the people of the country. He's the only federal official that's elected by the entire nation. He's also the only branch of the three branches of our government that is embodied in one person. The judicial branch has judges and the Supreme Court and multiple people. Congress has all the different states and senators and representatives. The presidency, the executive branch, is vested in one individual. And we trust, and the American people trust, rightly or wrongly. We've made some bad decisions for presidents. We've made some good ones. But that's the decision of the people of the United States, and they have the right to make a good decision or even a bad decision. But once they've trusted that individual to be president, and that person is human and will make mistakes and even do things wrong and even do things for the wrong motive. But if you take away the ability of that person who's entrusted to be the executive of the country, the authority to do so, or making them fear that they'll be criminally prosecuted by a political opponent, that then renders them incapable of making the decisions that are essential, particularly in foreign policy and national defense kind of questions. Could Truman have been prosecuted for dropping the nuclear bomb
Gosh,
on Hiroshima or Nagasaki?
we still debate about that.
So,
Rightfully so, I guess, looking
Right.
back in history. But I see your point crystal clear.
so that was why you asked, and I'm returning Lauren to the point. Why did the Constitutional Coalition think it was necessary to file this brief, this amicus brief with the Supreme Court? What's the value of that? And what we found and have learned both from the oral argument by the court itself is that they valued that opinion. They valued the opinion of somebody like former Attorney General John Ashcroft, who was not affiliated with the Trump administration, being able to say from the perspective of just the institution of the presidency, here are factors you should consider when you render this decision. And in my view, certainly the court rendered the exactly correct decision that they did. So it was gratifying to see that we'd had that opportunity. It was gratifying to see that voice that we brought to that debate in the Supreme Court was helpful. And that's an example of where the Constitutional Coalition can support the Constitution by advocating for the Constitution itself. We weren't there advocating for President Trump. We weren't there advocating for the Republican Party. We were advocating for something more transcendent and more important, and that was the Constitution itself.
Excellent.
So,
Thank you.
good.